Good afternoon, everyone. Hope you're all doing well and are safe wherever you are today. My name is Jamin Chabda. I'm an attorney with Chugh LLP in the Atlanta, Georgia office. Thank you for joining our webinar today, and big thank you to Thai Atlanta, Amin, and JP for organizing the event. As we've all seen, there have been many changes in the law that affect small and medium businesses over the last few weeks. For example, the SBA announced 2 loan programs, the EIDL and PPP, each of which have programs that allow for certain funds to be forgiven if used for payroll. We'll have an update on that today. There have been various updates to employers that have H1 and L1 workers on their staff. And prior to changes in the law, there was no obligation for an employer to provide paid sick leave, which is now the norm for employers that have less than 500 employees. To prevent employers from terminating employees, the government is providing payroll tax credits for those employers that have employees on paid sick leave or expanded FMLA. And the federal government's giving unemployment benefits in addition to state benefits, which is new as well. Our teams across the US offices have been assisting clients with these new changes. And for today's webinar, we're providing an insight into what our clients have been asking us to provide a practical approach for you as the listener to how these 3 practice areas are affecting businesses. So we'll start with the loan programs. Asha in our Santa Clara office, who's a CPA, if you could please tell us about the EIDL loan that the SBA is offering.
Hi, Damon, and good morning, everyone. Thank you for attending the webinar, and we hope that you and your loved ones are safe. So to give you a little more background on the economic injury disaster loans, commonly referred to as the EIDL loans, these are part of the stimulus package that has been initiated by the federal government, basically managed by the Small Business Administration, that is the SBA. This is for the businesses that have suffered some kind of losses due to the COVID-19 situation. And this is solely managed by the SBA, so they're the only lender who's managing the whole loan package. Now, the eligibility initially was a different one, but now it's been changed to small businesses which have less than 500 employees, basically small businesses as defined by this SBA, and they have different classifications and different sizes defined according to the NAICS code. And that includes independent contractors. It includes cooperatives and employee-owned businesses. It also includes some private nonprofits and tribals whose small businesses have been on operation as on January 31st, 2020. But some religious charitable institutions, maybe 501c3 organizations, gambling institutions are not eligible. Some of them have questions like whether the startups with or without the venture capital funding would be eligible or not. Yeah, as of now, most of them are eligible, but they're being scrutinized a little more in detail because they would probably question, okay, if you have heavy backing by wealthy individuals, then that might be under the radar when you apply, but there's nothing barring them from applying as of now. But yes, there could be some caveats there. For the maximum loan amount that's available, the loans almost up to 2 million can be availed, and the stimulus package was initially announced for about 8 million. It's been another additional 10 million have been sanctioned. You can start applying all the way, it's already begun, and it started from January 31st, 2020. You can apply all the way until the end of this year. However, sooner you apply, the better, because applicants all over the country are applying online, and they're applying at the same time. So we just want to make sure that you don't miss out on the chance on getting the loan. The loans can be utilized for a variety of reasons. And basically, since this is to mitigate any kind of financial losses that you might have faced during this global pandemic, you could use the proceeds towards paying any fixed debt payment, the payroll costs, working capital costs. You could pay vendors, employee benefits such as sick leaves, etc. However, they cannot be used to refinance any pre-existing debt, as in any debt that you had beforehand, before the COVID-19 situation, which could be with with the SBA or with any other agency. You could not be using repaying any loans prior to that situation. or you could not use it to repair any kind of physical damage or paying dividends to your shareholders or penalties. Now, one additional thing to note about this EIDL loan is that later on, once you receive the proceeds, you can utilize part of it and convert it to a PPP loan. And I'll be covering that in a short while. And that's it from me,
Great.
Jim.
Thanks, Asha. So that was a good segue into the PPP loan. Obviously, it's also SBA backed, but through different lenders. Can you tell us about that, please?
Sure. So the Paycheck Protection Program, the PPP loans, have again been another stimulus granted to the small businesses, basically with less than 500 employees. This is purely for meeting payroll costs and to help ensure that they can retain their employees and not lay off or furlough anyone. This has been introduced again by the SBA, but it's being carried out and monitored and funded by any banks or lenders approved by the SBA to do the SBA 7A loans, and which are basically underwritten by the SBA. So a lot of these commercial banks and a few private financial tech institutions, even of late, some payroll processing companies like Gusto and QuickBooks have started, even PayPal has qualified. So there are a bunch of financial institutions who have been approved and are helping businesses fund this loan. So the eligibility again is very similar to the one that we discussed in EIDL, but there's a little difference here. So small businesses which have been in existence and operation as of February 15th, 2020, with less than 500 employees. Startups are also eligible. And again, as I mentioned earlier, if they have VC funding, they need to be a little extra careful. The US business entities, which are owned by foreign nationals, are also eligible as long as one of the owners, especially with 20% or more ownership, is a US citizen or a green card holder, because the application demands you to give their SSN. In the 500 employee count, one needs to note that only the employees living in the United States are counted. So the employees which are working from abroad or any contracted employees, people on 1099 are not counted. So, but in the 500 employee count, they need to take into account the employees of all the affiliates, which could include subsidiaries, parent entities, or entities under common ownership. So they need to be included as long as the employees are in the United States. So the maximum loan available is, there's a formula here to calculate the maximum loan. So we need to first arrive at the average monthly payroll cost. And again, there are a few things that need to be taken out of the calculation for the monthly payroll cost. And you need to limit the gross amount of payroll to 100,000 per employee. The maximum loan that you could avail under this program is 10 million. You can apply right away, and the application is already being processed by a lot of the banks. As I said, you can apply until June 30th, 2020. But in order to get the maximum benefit for you, especially for forgiveness, which Kapil is going to cover a little later, is to avail it by May 5th, 2020. You can utilize the loans for, again, majorly payroll. And in order to get the benefits of forgiveness, you should be at least utilizing 75% of it towards payroll costs. And you could use the balance for making any kind of mortgage loan payments, interest on pre-existing debts, but you cannot use it for prepaying any of those loans. You could use it for paying rent and utilities, but you cannot use it to pay 1099 or independent contractors or to any non-resident aliens, as in the ones who are not in the US. That's it from me, Jaden.
Thanks so much, Asha. So to talk about some of the documents that are necessary for the EIDL and PPP loans, Sailesh Patel from our Atlanta office, do you mind covering that, please?
Sure, Jamin. Thank you, Jamin and Asa, for starting all this webinar. Good morning and good afternoon to all the participants. So based on information Asa gave, like for EIDL and PPP, the summary of the document requirement is for, so first I will start with the PPP loan, which is the payroll protection program. And for that, like other than that filled out application based on as I mentioned with that proper calculation and everything. So the list of document required will be this summary is like based on the not specific bank because it varies from bank to bank and sometimes like big player they have like different requirement. So this is like big list compile out of like whatever our client who have applied so far and they were asked. So based on that, they will need articles of incorporation, bylaws or operating agreement, owner's driver license copy, the payroll returns like 940, 941s, supporting bank statement, uh, breakdown of payroll benefits like vacation, group health insurance, retirement benefit and everything. Also, you will need to provide like 1099s if there are any independent contractor in the calculation. Also, like there is one thing, the certification about all the employees live in the US, so that will be required. Generally, like some of the bank, they ask 12 months profit loss as a reference. Also, like some of the expenses can be utilized for the mortgage and rent. So also provide the most recent mortgage statement and the utility bill. So this is the big summary of the document required for PPP. Talking about the same thing for EIDL. So other than that filled out application, there will be SBA form 413, which is the personal financial statement that should be submitted. Schedule of liabilities form 2202. Another form like IRS tax transcript 45060 and the most recent tax return. So this is the big summary of the document requirement, Jamie.
Thanks, Salish. And practically, how soon are the banks funding each of the loans?
Yeah, I mean, I wish I would have like a specific answer for that, but unfortunately, based on like the volume and constantly ongoing changes, and sometime like what we have experienced, like our clients, so they started applying, and some of the big banks they were overwhelmed with the application, so that website was down or they could not handle. So based on whatever the information known so far, so initially EIDL was supposed to be paid out in 3 days, but like it may take like between 7 to 10 days because based on the latest information, so the application approval is already done for $160 billion, but there is like some kind of like execution or like administration thing between SBA and bank. So that is taking longer than expected. So for EIDL, like I'll say like 1 week. And for PPP, like wherever there are small bank players, so the estimated time is like 2 to 3 weeks. Again, it can vary depending on the bank and your relation with the bank and whatever the workload they have. So it's always like kind of a variable number rather than specific number of days, Jamin.
Great, thanks, Salish. And next we have Kapil Handa, CPA partner of the Atlanta office. Kapil, how do we determine which loans are better for the clients and the businesses?
Thank you, Jayman. Hello, everyone. Hope you are doing well. Thank you for attending our webinar. So it's a great question. Again, EIDL, which is Economic Injury Disaster Loan, it's really for people who are having the cash flow crunch or working capital deficiency, and they need the money now, even though the loan has a limit of up to $2 million, as Asha mentioned. But the good news is they can get up to $10,000 within few days. So, again, many of the businesses, as per the study done by one of the Chase Institute, they said an average small business has a cash flow up to 1 month's expenses. So we really need that. And in that case, EIDL can get you $10,000 right away within few days, hopefully sooner, and then get the things going, and you can qualify up to $2 million to get the working capital deficiency requirements met. So, and whereas PPP, which is Paycheck Protection Plan program, it is really to make sure that your employees are not let go, they are not laid off, to support the employees of the businesses. So the government doesn't want any of the employees to be let go because of this pandemic that happened during this time. So again, sum it up, EIDL is going to be for 1, to make sure the working capital deficiency has been met so that the businesses can keep the lights on. It is more for the survival of the businesses. Whereas the PPP program, it is really to make sure the employees of the businesses are retained and not let go, so that during this time they can be supported by the government. So I would like to add as well, just to kind of give you some reference in how it started. It started, the SBA loans have given $350 billion in the small business loans so far out of the $2.2 trillion package that was released. And they have been talks, and it's almost there that the $250 billion additional funding would be on its way. So the only challenge at this point is that the banks have been instructed and the government has authorized to lend the money. At this point, since last Friday, the SB has given the data that they have approved $161 billion, which entails 600,000 applications so far. However, the challenge is the money has not been hit in the client's bank accounts. So that's the struggle. So even though government has the instructions that were given and the SBA and the lenders have all the intentions to release the funds, they also want to make sure their due diligence has been met. So we have to really see a practical thing here. Again, not long ago, maybe in 2008-9, banks came under a lot of scrutiny. Why? Because they did this relaxed underwriting rules, and down the road, government said your rules were too relaxed, because of which your underwriting standards were not per the par. That's the reason right now they are doing extra due diligence, which is taking a little more time than we all would like. However, the government and the bank has all the intentions. It might take a little more time, but let me assure you, the money is on its way. That's it from Ajay.
Thank you, Kapil. Appreciate that. Just going back to Asha, can you please tell us if nonprofit organizations qualify for either one of the loans?
Sure, Jamin. So yes, they definitely do, but then the whole thing depends on how they're classified under the tax laws. So if they're classified under the tax laws, basically under 501A of the Internal Revenue Code, as a 501c3 or a 501c19, which is veteran organizations, then they do not qualify for the EIDL, but they do qualify for the Paycheck Protection Program, and all the regular norms that we discussed earlier today on the Paycheck Protection Program would apply to them. And for the other nonprofit organizations, such as 501c4 and 501c6 organizations like the trade unions or chambers of commerce, the ones having less than 500 employees as of 1st of March 2020, they would qualify for the EIDL loan. And again, all the EIDL loan application eligibility requirements and everything else would apply to them. But besides that, for sure, they do have a lot of other tax benefits and employee-related benefits granted to the nonprofits to help them in this crisis, such as deferral of payroll taxes, employee retention credit, etc. And we can discuss that later on more in detail. That's it from me.
Great, thanks, Asha. And Kapil, how are the EIDL and PPP loans impacting tax filings and tax payments?
Another great question, Jim. And again, one of the good things is IRS has been on the forefront since this thing happened, and they have relaxed the rules for filing and paying the taxes. Anything as of now, which was due by April 15, has been by default given a blanket 3 months extension. So be it be filing of the tax return or be it be making the payments, it is an automatic extension. Nobody has to go online, ask their CPAs to get the filing extended. It is an automatic, which by default, your CPAs should be aware of that. And anything which needs to be, even for that matter, 2020 estimated payments, which many of our clients and businesses would have also been extended for another 3 months, which is July 15. On top of it, a lot of us contribute for our IRAs, which is related to our pensions. You can again get up to another 3 months, which is July 15, to contribute towards your IRA accounts. Also HSA account, as many of us know, then which relates to the health savings accounts out of which we can pay our medical expenses. All those payments generally are supposed to be done by April 15th, but however, in this case, IRS has extended everything till July 15th. Another good news is even though states have been different on these extensions and filings, most of the states have been following what IRS said, but again, the states are a little different, their rules are different. So I would encourage anybody, for the benefit of the viewers and listeners, anybody has any specific questions on the state, please reach out to your CPAs and then they will be more than happy to help on that. That's it from my Jamin.
Thanks, Kapil. And going to Salish, is there any other aid available from the government for individuals and businesses that we haven't yet discussed?
Yes, Jamin. So I will give like summary of that. What are the other things available apart from PPP and EIDL? So for the business matter, like if they have not applied for PPP loan, in that case, so all the businesses, they can get up to 5,000 per employee, provided like the business has suffered during this COVID time, and they don't fire employee or furlough and hire them back. So based on that situation, they can get up 5,000 per employee, which is 50% of first 10,000. That will be the credit they can take on their payroll tax return. In the same line, employer, they can defer the Social Security and Medicare portion of the employer part. So whatever like they owe for 2020, so they can delay all that payment to pay 50% of that due amount by December 2021, and the remaining 50% by 2022. So that is some deferment. One more thing to add, like based on the like last year tax change, so that net operating loss carryback was removed. But now based on this situation, like so now IRS will allow them to carry it back, and so based on the higher tax bracket, businesses can go back and amend their like 2018 or 19 return, and they can get benefit of that NOL to get like more cash flow in their hand. Other than that, like some of these paid sick leave and everything, couple of family medical leave, which you already covered. Another thing is like Section 139 tax-free deductible payment that is available on the individual side. And we just came to know like many of our clients and like, yeah, so IRS has started sending that $1,200 per adult. So that part is already started dispersing, and $500 per child, they will get it. There are like certain individuals who are not required to file the tax return. In that case, so they will have to go to IRS website and give their personal information and bank information to get that $1,200. Only people who are not filing the return, but they are getting a social security benefit, so that will be automatic. Other than that, like Jamin, whatever you covered from the unemployment and Kapil covered that retirement distribution and everything. So that is the big summary, Jamin.
Thank you, Salish. And just going back to the loans for a second, to Kapil as well. What are the tax implications if the loan is forgiven, either one of the loans?
Sure, Jim. And again, if the loan is forgiven, the good news is there's no taxability, so there's no double taxation here. So what's going to happen? Let's suppose somebody had $100,000 in revenue, and $50,000 was the payroll. On an average, 50% is payroll in a service industry, and for some reason he gets $25,000 from the government. So in that case, they just get that funding from the government to pay their expenses, which again will be reducing their bottom line. So at the end of the day, whatever the loan is forgiven, there's not going to be any direct tax on that. In addition, Jim, and I would like to add again, coming back to EIDL and PPP, whichever loan. So for many, many clients, what we have done is we applied both EIDL and PPP loan, just to make sure some clients, some people have this misunderstanding, you know, they can either apply one or the other. The good news is they can apply both as long as the purpose of the loan is different. So EIDL may be just to keep the lights on to meet the working capital deficiency, whereas the PPP is to retain the employees. So just having this in understanding, yes, we can apply both the loans. Back to you, Jamin. Thank you.
Thanks so much, Kapil. And thank you everyone for sending your questions as well. I know there's a lot of questions about the loans. So we've got the immigration and the employment section coming up, and then we've got a large portion of today's hour webinar devoted just to Q&A. So we'll make sure and answer everyone's questions either live or on chat. So please keep the questions coming, and we'll definitely get to all of them. And then switching now to immigration, a big focus has been on H-1 employees and what employers are to do during this pandemic. So Dia Matthews, our accounting, attorney partner in the New Jersey office. Dia, can you please tell us what options employers have to reduce their payroll costs for H-1 employees?
Sure, will do, Jamin. So with H-1 employees or for H-1 employers, the main consideration is the LCA, the labor condition application, and that governs the most of the terms of the H-1B petition. The issue here is that an employer cannot deviate from the terms of the LCA. So that's why reduction of salary and wages is usually not permitted unless you file an amendment. The caveat to that is that if it's the H-1B employee that has requested time off for a personal reason, then that's fine. The employer is not required to pay wages during the time off that is requested by the employee. But if the H-1B employer reduces wages or hours because of lack of work, that's not permitted under the H-1B regulations unless the employer files an amendment. And generally, the expectation was that USCIS, which is the administrative agency that governs immigration matters here, that they would issue some sort of a declaration or some sort of relaxation of the rules considering the current pandemic. Unfortunately, they've not really made any accommodations at this time. So employers are held to the current standard when it comes to H-1B obligations. But in terms of the practical options to reduce payroll, the first option would be obviously terminating the H-1B employee. And if the employer chooses to do that, then make sure that they follow all the requirements for a valid termination. In immigration terms, that includes sending a notice to the employer and to the employee, as well as to USCIS. And also, and this is very important, making an offer of return transportation back to the home country for the H-1B employee. Another option is to lower the salary to what is actually listed on the petition. So the petition was filed specifying a certain wage, and the employer ends up actually paying more than that for contractual reasons. You have the option of reducing it further to what's the bare minimum that is listed on the petition, the H-1B petition itself. Another option would be to lower the salary for now, considering the cash flow issues and things like that, and then make up with a bonus at the end of the year. Right. So the key aspect here is that the shortfall has to be made up for by the end of the year. And then going back, the last option would be to reduce the salary or the wages and file a corresponding H-1B amendment petition with USCIS. Yeah. So that's just a few of the options for reducing payroll costs for H-1B employees.
Yeah, and for the H-1B employees working from home due to the pandemic, is an amendment necessary?
Yes, so that's the question that we're getting regularly these days, because pretty much everybody has to work from home these days, right? So I guess the quick answer is generally no, you're not required to file an amendment. And the reason is that usually when somebody is working from home, it's because they live within commuting distance of the actual work site. And so the LCA already covers the employee's home office because the LCA is generally good for the area in general, which is defined as the radius of commuting distance, or the same MSA, which is Metropolitan Statistical Area. So generally, as long as the employee's home office is, the home is within a commuting distance of the work site, you don't need to file an amendment petition. You don't need to file a new LCA. You are, however, required to ensure that the LCA, the original LCA, is posted at the employee's home office for 10 days.
Great. What's the short-term placement option?
Yes, again, that's the short-term placement option is it's defined as an exception to the general requirement that when there is a change in an H-1B employee's work site, the employer has to file an amendment petition, right? So the short-term placement exception provides that for a period of 30 days, 30 work days, the employee is allowed to be at a new work site without the employer having to file an H-1B amendment. But there are some additional requirements around this. So for example, just very briefly, the employer should provide the actual cost of lodging for each day. Should also provide a per diem to cover meals and things like that, because this is meant to be a temporary, very temporary work arrangement, not exceeding 30 days, and the employee is supposed to have a main base at the employer's original work site. So not exceeding 30 days, and employer should pay a per diem. Yeah.
Great, thanks, Dia. Similarly, Hafiz, you did from our New York office. Could you please tell us what options the employers have to reduce payroll costs for the L1 employees?
Thank you, Jamin. So generally, there's comparatively greater flexibility with regard to L1 wages and compensation requirements as compared to other categories such as the H-1B. There's no LCA involved, so there's really no prevailing wage requirement. However, as a matter of best practice, we always recommend filing an amendment to ensure strict compliance in the event of a future issue like an audit or some other compliance matter comes up. So it's always best to do the amendment. However, it's not necessarily absolutely necessary that it be done, but we do recommend it as a best practice. Also, it's noteworthy in doing this that salaries, payments, and wage payments are usually used in connection with future extensions or in connection with filings down the line with respect to green cards, EB-1 filings, I-140, ability to pay issues, and so forth. So those are things that should be considered when potential wage reductions are done in the context of an L1. Another issue to consider also is whether the salary may be reduced too much such that the position itself and its bona fides are questioned. And L1 generally applies to executives or managers who are supposed to be earning a certain level of salary, and that should reflect their hierarchy within the company structure. So significant reductions could potentially be a problem. Also, excess reduction could trigger poverty guideline limits. Sometimes if the individual has family members and if you're cutting wages too low, you may impact whether the ability for the individual to cover the requirements for the family and the requirements of the alien to be able to cover their means of staying in the US and covering for their family. So those are some things that need to be considered. But generally speaking, there's no per se prohibition, but so long as these considerations are taken into account. One other thing, as far as I did mention earlier, it definitely needs to be considered whether the ability to pay may subsequently be impacted. If the individual has a future green card petition in the pipeline, it may impact whether the company has the ability to show that they can cover the salaries and the wages for this individual. So that's another important consideration.
Great, thanks, Hafiz. And so practically speaking, there are certain H1 or L1 employees that are unable to leave the country at this time. So can an employer continue to pay the H1 or L1 employee, and what other options are available to help financially?
So the employer is not prohibited from paying or covering any cost of an employee. However, shouldn't be some kind of a disguise to compensation for in reward for unauthorized employment. So long as it's not a workaround to some kind of a compensation for unauthorized employment, shouldn't be a problem. So this can come in the form of a bonus or severance pay. Unlike H1 employees, L1 employers are not required to provide a return ticket, but they can certainly assist the employee if they want. One thing I also wanted to just add with respect to the L1 employees, in the event they're not able to reduce, or if there's no other options, the individual can switch to B1, B2. You can also do an amendment to a lower wage, even part-time. Just want to add that. All right.
Great. Thanks, Hafiz.
Great. Thank you, Jamin. Again, this is now we're gonna segue into our legal webinar. So what we're gonna do is there are many questions that the businesses and individuals have, and they are asking pertaining to employment matters. And to understand the details authorized by our government, we have Prima Rothman, corporate attorney at our New York office. So Prima, if you can please tell us what are the reasons that an employee can take leave during this COVID-19?
Sure. Thank you, Kapil. Eligible employees can take leave for a qualifying need related to a public health emergency. Under this Emergency Paid Sick Leave Act, which is called the Families First Coronavirus Response Act, an employee qualifies for paid sick time if the employee is unable to work or unable to telework due to a need for leave because the employee is either subject to a federal, state, or local quarantine or isolation order related to COVID-19, or has been advised by a healthcare provider to self-quarantine related to COVID-19, or is experiencing COVID-19 symptoms and is seeking a medical diagnosis. Additionally, an employee can also take leave if he or she is caring for an individual subject to an order of self-quarantine, or is caring for a child whose school or place of care is closed, or childcare provider is unavailable for reasons related to COVID-19. There's also provision available to take leave if an employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. So under this new Paid Sick Leave Act, an employee qualifies for extended family leave if the employee is caring for a child whose school or place of care is closed, or if the childcare provider is unavailable for longer periods of time. Back to you, Kapil.
Great, thank you, Prema. So in this follow-up question, can employees use sick leave before this Family First Corona Response Act, or can they use PTO, paid time off? If you can, please elaborate, Prema.
Sure, great question. An employee affected by COVID-19 has the right to use the provisions of the new emergency sick leave before using any of their existing PTO benefits provided through their employer. An employer cannot require an employee to use their PTO prior to receiving this paid sick leave under the new law. This new paid sick emergency leave, also, it's important to remember that it does not impact with the leave under the employment contracts, employment agreements, handbooks, state or federal law that applies. So the employers must take all the applicable laws and their obligations into consideration. Also, it's important to note that the total leave under the FMLA, including leave under the emergency paid sick leave, and along with the existing ones, is limited to 12 weeks. So that's something the employers need to keep in mind as well. Back to you.
Great. Another question, Prema, we are hearing this. What is this emergency paid family leave under this FMLA? If you can discuss that.
Sure. So as we discussed earlier, once an employee is qualified to get under this Emergency Paid Sick Leave Act, which is the Families First Coronavirus Response Act, they can then avail up to, if they are qualified,
then they can get 2 weeks of paid sick leave up to 80 hours at the employee's regular rate of pay, whether they are full-time or part-time, where the employee is unable to work because the employee is quarantined or is experiencing COVID-19 symptoms, like we discussed before, if any of those reasons apply. Additionally, if the employee is caring for somebody else or a child, they can also get up to 2 weeks or up to 80 hours of paid sick leave at 2/3 the employee's regular rate of pay under this Emergency Paid Sick Leave Act, which is, I believe a lot of people can make use of that. Additionally, up to an additional 10 weeks of paid expanded family and medical leave at 2/3 of the employee's regular rate of pay for an eligible employee is also available, as long as the employee has been employed for at least 30 calendar days with this employer.
Thank you, Prema. Again, another question we are getting is, given the government is forcing many businesses to close down during this health pandemic, what can companies and employers do to save on payroll costs? So Jamin, if you can please help us understand this, which is a very common question we are getting from many businesses.
Sure, thanks, Kapil. So as previously mentioned, the employers can reduce hours or terminate their employees either on a temporary or permanent basis, subject to their immigration status or a notice from an employee that they are taking the leaves that Prema just mentioned a minute ago. Employees in the US are generally at will, so that means that an employer can change the terms and conditions of the employment with or without notice or cause, unless there's a contract or certain other terms of employment state otherwise. And there's aspects of unemployment that we'll cover later on as well, essentially, that will help the employees if they get a wage reduction or time reduction.
Okay. Thank you, Jamin. Another question we are getting, Prema, this is maybe for you. If you can help us, how much will employees receive for this FMLA leave, right? So leave is sanctioned, has been authorized, but how much an employee can expect to receive out of this?
Yeah, so it's important to note that full-time employees get paid up to 80 hours of their regular rate of pay. But there is a maximum limit of $511 per day, or an aggregate of $5,110 for the entire period of time. Part-time employees are also eligible to get paid at their regular rate of pay for the number of hours that they normally are scheduled to work over that period. It's calculated by an average of what they have worked if they are part-time. And for employees using the family leave provision to take care of a child or other family member, they get paid 2/3 of their regular rate or 2/3 of the applicable minimum wage, but there is a maximum of $200 per day for an aggregate of $2,000 for those for the 10 days that they are eligible for it. However, under the extended family leave application applicable for an additional 10 weeks for employees who have worked for the employer for at least 30 days, they are eligible for an additional 10 weeks of this pay for 2/3 of their regular pay for a maximum of $200 per day or an aggregate of $10,000. So I do think that most of the employees who are unable to work should make use of this facility available. Back to you, Kapil.
Thanks, Prema. Jamin, this is for you. So what are the best practices for terminating an employee during this pandemic? If you can share that, please.
Sure. So obviously a video call, Zoom or Teams or whatever the normal course is preferable. And communication to the employee, just make sure that they clearly know what the issues are that are leading to termination, whether it's performance-based or if it's a layoff, which we will discuss later. Documentation is needed. So if we're taking Georgia as an example, a separation notice is necessary from the employer to the employee to take to the Department of Labor to apply for unemployment benefits. So those are definitely necessary. If there's a release agreement or anything like that, a non-compete essentially that they've signed, just to provide that documentation to them. Securing the company property is probably the key thing here, laptops, keys, that type of thing. So be careful asking another employee to go and pick it up, especially during this time where we're practicing social distancing. But overnighting it with FedEx or UPS, something like that would be ideal. Again, using Georgia as an example, the payday laws are different per state. But for example, in Georgia, the final check needs to be provided during the normal course. We usually do that within a couple of days maximum. But if you have a specific question in terms of can I withhold a check or something like that, that's kind of a difficult situation to discuss in general terms. So just contact one of us and we can kind of go through that with you.
Yeah, good information, Jim. And again, what we are understanding is documentation is the key, and then you touched on other points as well, which is great. So another point is this furloughing and laying off. We get this question: what is the difference between laying off a person or furloughing? If you can elaborate on that.
Yeah, that's a great question. So a layoff is a termination of an employee for non-performance related reasons, and it could be temporary or permanent. For temporary reasons, a certain lump sum cash payment can be made, or they can still avail of COBRA or certain benefits, perhaps if they have it for a certain amount of time. A furlough is an alternative to a layoff where the worker is still employed, but they're paid less. So when an employer furloughs its employees, it requires them to work fewer hours in that particular week, or take a certain amount of unpaid time off. So for example, if a company needed to furlough an exempt employee, they should do it for a full week so that it doesn't affect or jeopardize their exempt status under the law. So furlough that encompasses a full work week is one way to do that, instead of doing partial time for a particular week. And then there's a third option as well, a reduction in force, which is where it's not a layoff or a furlough, but essentially the position is eliminated altogether, and there's no intention of replacing that position or employee.
Great. So, Jim, and another question is, how employees qualify for unemployment? Which employees qualify for unemployment benefits? Do laid off and furloughed employees qualify as well? If you can help us understand that.
Yeah, that's something that we've been getting quite a bit. So previously, it's the state law generally governs which employees qualify for unemployment benefits, but right now it's pretty much, with limited exceptions, it's pretty much everyone. So gig workers, contractors, and other workers that wouldn't normally qualify for unemployment compensation, they qualify currently because they can't work due to the pandemic. So right now, the FFCRA that Prema was talking about is providing $1 billion in aid to state governments and the state departments of labor, as long as they have a qualifying reason. And it also waives any waiting period that was previously there. And previous times prior to all this, again, social distancing, the employee was requested to go in person, but now they're all online forms. And it's also waiving the work search requirements because there's only certain industries that are hiring currently. So it's relaxed on those particular requirements. So the second part of the question is, do laid off and furloughed employees qualify? Yeah, they absolutely do. They would receive the state unemployment benefits based on their salary, and another $600 a week for 4 months from the federal government.
Okay, great. Jim, and I think just to add on what you just said, I think my understanding is H1s and L1s, people who are on immigration status, they also do not qualify for unemployment benefits. But I think other than that, I think you covered it all. Thank you for that. So at this point, we are done with our presentation slides. However, we are open for questions. Please raise your hand. Please keep on asking the questions on the live chat. We are here for a few minutes and we'll be happy to answer your questions. Back to you, Jamin.
Thanks so much, Kapil. So some of the questions that we've received so far, we'll just kind of cover them. So some of the repeats at least. I think I'll turn to Asha for this one. Can the EIDL loan be used to pay down lines of credit or previous debt that's been incurred by the business?
Yeah, sure, Jamin. So then for the previous debts, clearly no, because the EIDL guidelines say that you cannot. But I believe that line of credit is not really like a fixed debt or something that you pay a monthly amount or something like that. It's just that it's an open loan, like a credit card that you're using. So that should be allowed. But yes, if it's any other pre-existing loan, whether with the SBA or with any other bank, you cannot use the funds for paying those.
Great. Thanks, Asha. And then
I think, Jamin, one of the questions they were asking is, can I get an EIDL loan? And if that EIDL loan can be used to pay the interest expense of the loan that they already have, not the EIDL loan, but any other loan the business already have. And the answer to that is yes. Again, the EIDL says, you can get that loan, and that working capital deficiency loan that you're going to get out of EIDL is generally pertaining to make sure you are able to meet the operating expenses requirement of the business. So yes, in that situation, interest expense of the existing loan that they might have does qualify.
Yes, Jamin. Shailesh here. So if I can take one question from like anonymous attendee there.
Yes, please.
Question is how is PPP loan repayment to be done? So the PPP loan is a loan with forgiveness component in it. So let's say business applied for typical monthly payroll is 20,000, for example. I'm just using one number. So they will get 50,000, which is 2.5 times 20. So business will get 50,000 PPP loan. And so from the day they receive that 50,000, when they use that 50,000 to pay for payroll, rent or mortgage interest and utility, but as long as 75% should be part of payroll. So assuming they utilize all that 50 for that valid expenses, in that case, they don't have to pay it back. Everything will be forgiven. For example, let's assume like 5,000 was kind of non-qualified expense. So in that remaining 5,000 to be paid back to SBA with 1% of annual interest rate, and the loan term is 2 years. So that is the like unforgiven part.
Great, thanks, Elish. And then there's one that again, this could be for any of you three. Can a corporation registered in the United States who is a 100% subsidiary of India, can they apply for the PPP loan? Is there any specific criteria for an application in this matter?
Yeah, Jayman, this is Kapil. Again, there were very stringent affiliation rules that SBA and the government came to begin with. But now as we move forward, they are getting a little relaxed on that. And the new definition and the new interpretation that we have at the moment is any business who's a United States business, irrespective of the ownership, and they're going to count the employees of the US business who are employed within the territory of US, they will qualify irrespective of the ownership of that entity. So at this point, that's the interpretation. Again, it's a moving target. There are many regulations which are getting revised and revisited. So at this point, that's what we have.
Great, thanks, Kapil. And can you all talk about the interest rates for the different, the EIDL and the PPP loans? I know there's different aspects of that. One of the questions were the interest rates for either one of the loans.
So, Jamin, I can answer that. So for the PPP, the interest rate is 1%. And for the EIDL, initially they announced it to be a max of 4%, but we have a little more clarity there. So it's 3.75 for small businesses. And if it's a nonprofit, the private nonprofits that I talked about, it's 2.75.
Great. Thanks, Asha. And this latest one, is the 75% employment requirement of the PPP loan used to cover payroll forgiven, or is it the full 100% that's forgiven?
Again, Jamin, as long as the money is used and 75% of the funds that they receive has been used to pay the payroll, then the 100% of the loan will be qualified to be forgiven. So as long as they pay 75% of the loan that they receive towards the payroll cost, yes, the entire 100% will be forgiven.
Okay, great, thanks. And I've seen a couple of immigration questions about F1 students on OPT. Dia, if you don't mind, could you please talk about that and whether they're eligible for unemployment?
So the question is whether OPT students are eligible for unemployment insurance?
Yes, that's correct.
Is that okay? Yes, good question. Unemployment laws are generally governed by the state provisions. And one of the requirements is that you have to be open and available to take employment, right? So the advantage for students in OPT status is that they don't have any restriction. They pretty much have open market employment authorization because of the EAD. And so, they should be eligible for, they certainly should be eligible to apply for the unemployment insurance, but there might be other requirements for that state. For example, the requirement that you should have worked in the last 6 months, etc. So depending on whether the student meets those requirements, they can definitely apply. I don't think there's any harm in applying, and we don't expect any immigration consequences for them as a result of applying for the unemployment insurance. I would think it's just a matter of eligibility. Hafiz, do you have any thoughts on this?
Hey, Dia. So I think I saw Min did address some of this on the chat there. I think there would be some differentiation with respect to a STEM employee, OPT holder, I think, because the requirement is that they're working in a related field, and then there's also the E-Verify requirement. So I would go, as you said, on a case-by-case basis, apply and see, make truthful representations on the forms, and see. It may work, but there are some potential issues that can come up, especially with respect to a STEM OPT, I would think.
Great, thanks, Dia and Hafiz. And Hafiz, while we have you there, can you talk about whether an H-1B employee can be furloughed?
They can certainly be furloughed, but it would impact their H-1 status, obviously. Anytime the H-1 employee, as Dia spoke about earlier, is not employed in accordance with their H-1B petition and complying with LCA obligations, which requires the prevailing wage payments, it impacts their status. So no would be the answer. It would affect their status.
Okay. Wonderful. Sasha, do we have other questions here that we haven't yet covered? There's a couple of attendees that have some questions, and I think you're unmuted. The first one is Paul Lopez. I think you're unmuted.
Okay, only if you think you're about to end. Number one question is, if people, given that there's just been incredible participation, I understand close to 100. So on behalf of the board and on behalf of all of TIE Atlanta, thanks to all of you from around the country for helping us with some great information in watching the 33 questions that have been put it on chat, you can tell a lot of valuable information. What's the next step if people continue to have questions? Should we stay on and do a less formal connection through chat? Is there an email they should send to? What's the next step other than saying thank you?
Good question. We're happy to stay on for a few more minutes, and then I'll just one caveat to that: any specific questions that get into too much of legal or accounting advice, we'd ask that we kind of take that offline. But we're happy to stay on for a bit, and then we will have our presentation available to everyone with the contact information for the specific individuals that they need to contact.
Last comment in general before we get back into content is to say thanks. I believe that the attendance is an indication that's even above what we had at our monthly meetings. So thanks for what you folks do, though. I am going to hold Jamin and Kapil up for having better snacks next time. So no, seriously, thank you all.
Thank you, Paul. I think we've got a couple more there. Vijay Bor, are you, I believe you're unmuted.
Hi, thank you for answering the questions. I've been affected yesterday by COVID-19 layoffs, and my termination date is, I got my separation document. My termination date is mentioned to be today, but the severance package says it's 2 months of worth of my basic salary. I'm on H1 visa, so I wasn't, it didn't mention how long I'll be on payroll. So I wanted to understand what's the norm, like do they distribute the salary in bi-weekly payments for 2 months, or if not, can I request HR to do so? That's my question.
Hi,
Sure.
this is Dia. I think it's a little specific, this particular question. So, we'd like this caller to contact us offline and we'll discuss it with him.
Cool, thank you.
Thanks so much for the question, Vijay. And Richa, I believe you're unmuted as well.
Hello. Yeah, so I had a question regarding the 60-day grace period that we get. So when does that period start? Is it like from the last day of your paycheck, or is it when your employer just informs you that you are like your role is no longer required and you are terminated? So when does that 60 days start?
Should I go ahead?
Yes, please, Dia.
Okay, I think Min also addressed this in one of the chats, but generally the 60-day period starts from the day the H-1B employment is terminated. And termination in the H-1B context has to meet all the requirements under the regulations in terms of notifying the employee, notifying USCIS, and the offer of return transportation being made. So from the day that these requirements are met, that is when the 60-day period would run.
Okay.
Great. There are a few very specific questions here, and kind of what I mentioned and Dia mentioned as well. If we could just take it offline. If there are some general questions, there's one here that I don't mind answering. If a PPP or EIDL loan is denied, is there an appeal process? I don't know if they've come out with a regulation yet, but I'd probably defer to Kapil or Sailesh or Asha for that. But I think that's still forthcoming. Is that right?
You're right, Jim. And at this point, if that anything it's denied, we'll have to go back to the bank, especially in the PPP, and just work with the bank and go through the process. And EIDL, again, it's directly with the SBA. So there is no middleman at the moment. Everything is going online. So we would really have to hold and see what is next. But yeah, as you said, that's the situation at the moment.
Great. Thank you, Kapil. All right, everyone. Thank you so much for your time today. I really appreciate it. And again, thank you to Thai Atlanta, to JP, Amin, Paul, everyone on the board, and to our panelists, Prema, Asha, Kapil, Sailesh, Dia, Hafiz, and then everyone that was answering questions that you didn't hear from, Min, Bhakti, and Kushbu. Thank you, everyone, for your time, and really appreciate it. Hope again that you all stay safe and healthy, and we'll talk to you again soon.